Good morning, everybody. Nice to be here. I am a 1984 graduate of Yale Law School, so I lived in New Haven for 4 years of my life, and so it's nice to be back in Connecticut, and it's nice to be with all of you today. What I was originally asked to talk about when I was called by the folks at OHRP and at Hartford Hospital was to talk about the final issuance, the issuance of the final common rule, and that hasn't happened yet. And so the topic of my talk, therefore, was taken out from under us, and then the question was what I would talk about. So what I propose to talk about, and what I will talk about, is the issue of returning test results to human subjects. That is, returning research test results to human subjects, and the regulatory and the ethical dilemmas in regard to returning those kinds of results. And I'll give you some of the regulatory issues that we have talked about that you may be dealing with every day, but certainly that we within the HHS Secretary's Advisory Committee on Human Research Protections have been talking about for the past couple of years. I will say, however, at the beginning, a few words about the possible issuance of the final rule. And I'll tell you, what I tell you is based on gossip, hearsay, innuendo, and nothing else. But that will not stop me from repeating it, and I believe it to be true. And that is that I think that before the end of the Obama administration, we will see the issuance of a final set of amendments to the Common Rule. I do believe that. That's what I hear. The other thing that I hear is that we will likely see some significant change to what was proposed in regard to the biospecimen consent. And if that is true, then that will be a welcome change, I think, for many of us, because I think that many of us have been afraid of what was proposed in both the ANPRM and the NPRM would mean for future research using human biospecimens. So we are hopeful. We are holding our breath, but we don't know when it's going to come down. I hope that it comes down sooner. Let me just tell you this: those of you who were around research will remember, and around healthcare will remember, that the HIPAA rule, the HIPAA privacy rule was released in the last few days of the Clinton administration. And it was done in such a hurried fashion that it had many problems and inconsistencies in it. So the first thing that the Bush administration, I think it was Mike Leavitt was Bush's HHS secretary at that point, one of the first things that Leavitt did was actually to pull back the rule within days of George W. Bush taking office and proceeding to another round of comments and amendments on the HIPAA privacy rule. So I am hoping, perhaps beyond hope, that the issuance of the final common rule will not be quite so hurried and will be more deliberate and will not need to be revoked or pulled back by whoever it is who wins on November 8th. So what I will talk about today is the issue of returning research test results. This issue is part of a larger set of issues in regard to transparency of research. And we see demands for transparency of research in many different places, manifest themselves in many different ways. One of the things that I'm not going to dwell on, but I think it's worth mentioning, is that there are some deep currents in regard to transparency of research results, transparency of research itself. One of the things, of course, that many of us are familiar with and that we have to deal with every day is registering our clinical trials on HHS.gov, and then in turn putting our results of studies, once they're completed, into the results registry on HHS.gov. I think most people in this room are familiar with that process. We also know that there are increasingly a number of journals, including the British Medical Journal, that actually require, and NIH in some cases requires that when one has a study that is whose results are submitted to BMJ for possible publication, one of the pledges that the authors must take is that they will make all of their data, their raw data, de-identified, but their raw data available to whatever secondary researchers, whoever the secondary researchers are, may ask for the data. We also know that the International Committee of Medical Journal Editors, ICMJE, has endorsed in principle the theory that all of the ICMJ journals would make it as a condition of publication of any results of any trial or experiment in their journals that the authors would make raw data available to any qualified researcher, secondary researcher who asks for it. Are those of you in the room familiar with these things that are going on? The other thing that's going on in that regard is that the European Medicines Agency, which is the analog in the EU, of course, of our own FDA, has indicated that it too will require that in a way that overlaps some of what the ICMJ is proposing in this way, that when one is an industry sponsor of research and one moves to in the EU before the EMA to have one's medicinal product approved for marketing and for advertising and marketing within the EU member states, that one would have to make all of the raw data available even on the web to anyone who might want to look at it, down to the patient level, not with identifiers, but all of the raw data available as a condition of having one's drug approved for marketing within the European Union. This means that, lest you think that doesn't affect us, it actually affects us very directly, because it means that all of the clinical studies, whether they're done in Hartford or New Haven or Bridgeport or New York or California, or the EU or even in Polynesia, wherever the studies may be done, if the studies are going to be submitted to support an EMA marketing application, which they will be, then that means that our data, our patient data, de-identified, but our patient data down to the patient level, and I'm talking the blood pressure readings, if they're required by the research protocol, would all be made available publicly to any secondary researcher or any member of the public who would like to see these things. So these are all sort of mega trends. These are some individual manifestations of a mega trend toward greater transparency in clinical research. Maybe, for example, that in the final issuance of the Common Rule, one of the things that we'll see what was proposed in the NPRM, which is that the informed consent forms should be made available on the web for studies that are active. We may see that. It would not surprise me at all if we see that in the final Common Rule. So what I'm about to talk about is another aspect of the overall trend toward greater transparency in research. I have no direct conflicts of interest, I believe, in all of this. So we're going to go over these things, and this is quite a specific presentation, which may or may not impact you directly right now, but I believe that if it doesn't impact you directly right now in terms of the research that you either are overseeing, monitoring, or conducting, it will impact you at some point, because we see that these issues are emerging with greater force. But what I'm going to talk about is basically this. I'll give you a background of the issue. We'll talk a little bit about the HIPAA right of the individual patient or research subject to access their data that are held by a covered entity under HIPAA. And of course, almost all of our healthcare institutions, down to the office practices of individual physicians, are all covered entities. There are only a few exceptions to that. We'll talk about the issuance of the joint HIPAA-CLIA Common Rule, that is the Clinical Laboratory Improvement Act, which most of us, when we entered research, did not think that we would be worried about the Clinical Laboratory Improvement Act, but it actually matters very much, as I'll show you. There is a regulatory conflict between the HIPAA right of access and some of the CLIA requirements, which I'll talk about. SACHRP, the HHS Secretary's Advisory Committee, which is the advisory committee to OHRP and to the HHS Secretary on Human Research, has some recommendations. I'll talk about recent developments, and then I'll talk a bit about the FDA regulations, because even if the HIPAA and the CLIA things don't apply to you or to the research that you are planning or conducting or overseeing or monitoring, then FDA regulations in this area may well apply. So here is a case study, an example of one of the things that can happen in this area. A participant enrolls in research involving genetic sequencing tests. You could also have biomarkers instead of genetic sequencing tests. And they are conducted in an academic medical center or any hospitals, HIPAA-covered entity hospitals, a research lab. But the research lab itself, is not the regular pathology laboratory. It is a separate research laboratory that is within the wet lab of a particular PI. And most of our PI laboratories that are not pathology labs are not CLIA certified, as I think most of you know. A participant, knowing that he or she is enrolled in research and that test results have been generated, could be genetic test results, it could be biomarker test results, asks for a copy of the final test results. How do the researcher and the medical center or hospital respond to this? And how do the individual right of access to these under HIPAA, how does that affect the analysis in this case? We know under HIPAA, and so that's the paradigmatic case that I'll be referring to throughout the presentation. We know under HIPAA that an individual has a right of access to the designated record set held about them by the covered entity. The only healthcare providers that are not covered entities may be the Shriners hospitals, which don't bill Medicare and Medicaid, and a few dental and psychiatry practices that only take checks and cash. Otherwise, you perform one electronic transaction for reimbursement and your entire operation is subjected to HIPAA for these purposes. HIPAA's right of access is not actually a right of access of the individual patient, is not a right of access to everything held by the covered entity, but instead it's defined as a right of access to what's called a designated record set, or DRS. A technicality which may be known pretty much only to your HIPAA privacy officers, but is quite important to this analysis today. What does that include? A designated record set includes medical records and billing records that are maintained on the individual. It includes enrollment and payment information, all the reimbursement information and claims information. But most importantly for this purpose, it is any other records, all other records that are used in whole or in part by the covered entity to make decisions about individuals. So it's not just decisions about treatment, but it's any decision. And it's not just a decision about the patient, it's a decision about any individual. This is the way that a designated record set is defined. So the right of access is to a designated record set. In 2003, when the Bush administration came out with the final privacy rule after all of its amendments, then the privacy rule provided flexibility regarding the access right with respect to information that is generated during research. It did say, and I think all of us know this, that in the informed consent, if you give research subjects notice, you can say to them, you cannot have access, even though we're within a covered entity and this research is done within a HIPAA covered entity, you can't have access to your information during the course of the trial. But once the trial is over and your participation is ended, then you can have access. Now, why is that? Because otherwise people would be asking, people who are in a randomized controlled study would want to know immediately, if they were smart and they actually knew what they were talking about and they knew what research was and how it was structured, they would ask immediately all of their medical records, because then they would know whether they're in the control arm or they're in the experimental arm of the study. So, but it has to be in the consent in order to suspend the access right during the study. Under the 2003 privacy rule, in addition, individuals could, outside of research, they would often, and they do today, they file records requests, and they get all of their pathology results, all of their progress notes, they get everything. However, the privacy rule did not mandate that laboratories that are covered entities, either those that are CLIA exempt or those that, like research labs, or those that are certified under CLIA, provide individuals with direct access. So they can get their results if it's part of their overall medical record, but if you go to a freestanding laboratory, even though that is a covered entity under HIPAA, under the 2003 privacy rule, the clinical laboratory did not have to give you your raw results. And why is that? Because the HIPAA drafters were trying to preserve the regulatory structure of CLIA, the Clinical Laboratory Improvement Act, which basically said that individuals did not have a right of access to their test results from the commercial or non-commercial CLIA laboratory, because CLIA wanted individuals to have to go through a learned intermediary, that is the physician who had ordered the test, in order to get their test results. The CLIA folks are sort of behind the curve on the transparency, as I'll get to in a minute, but they clearly were behind the curve at this point, because they thought the CLIA regulators who are within CMS, the Center for Medicare and Medicaid Services, they want there to be greater control rather than greater access. And so they preferred, and the regulations, the CLIA regulations traditionally and still today are structured so that the doctor or the provider stands in between the individual and his or her test results so that the doctor can interpret the test results. So if CLIA prohibited disclosure to an individual, the laboratory under HIPAA, under the original issuance, was not required to provide access to those laboratory records. However, transparency, the tide of transparency, either, I guess one could say it either lifts all boats or it wrecks all boats, depending on your point of view, whether you're a HIPAA access advocate or whether you are a CLIA advocate who would prefer that individuals be protected in one way or another from their information. There was a joint HIPAA-CLIA rule that was issued in 2014 with an intent to harmonize CLIA and HIPAA in regard to some of these individual access rights. It was had a compliance deadline of October 6th of 2014, so it's now been in effect for over 2 years. This act amended CLIA to allow labs to give completed test results directly to a patient or his or her legally authorized representative, and it amended HIPAA to require HIPAA-covered entity laboratories to provide access rights to patients. Now, none of this affects yet, and what we're talking about affects research. So under this rule, therefore, MedPath, any ClinPath, any of the individual laboratories that are covered entities, and they're all covered entities because they all apply for reimbursement to Medicare, Medicaid, and private insurance and managed care. If you go as a patient, as a consumer to that place that has run a test on you and you ask for your designated record set, they have to give you all the information without going through the individual doctor. So the individual right of access was protected and allowed under this rule. Why the change? HHS was trying to be transparent. It's consistent actually with some of what President Obama has said in regard to the Precision Medicine Initiative, which is to give people more information about their health. The history of this act said that the idea was to remove barriers in the regulations to individual access to test reports maintained by laboratories subject to or exempt from CLIA, enabling individuals to be more proactive and more informed with regard to their health through commitment to personalized medicine. And the preamble noted, and this is leaving aside the silencing really the objections of some of the traditional folks in CLIA who had this idea that there should be, that we want the intermediary, the learned intermediary, the physician, to stand in between the patient and their laboratory test results. The preamble noted that even when individual access to test results, to lab test results may cause anxiety, such concerns are not sufficient to justify denial of access. So transparency triumphs in this 2014 Act. So clearly favors individual access, but here's the problem. Under CLIA, what remained behind after the 2014 Act is the CLIA prohibition on non-CLIA certified laboratories being able to give individuals test results. And CLIA says that a non-CLIA certified laboratory, which is most of our research laboratories, that are doing genetic testing, that are doing biomarker testing, most of these research laboratories are not our regular pathology labs. They are not CLIA certified. And so this rule left behind the idea and the inconsistency in this law, which says that if it's not a CLIA, and this is still the law, if it is not a CLIA certified laboratory, it is illegal under CLIA for the laboratory to give out the test results. Now, why is that? Why is that? Well, there are some merits. There are some merits on the side of the CLIA regulators, because in general, what they're concerned about is the following, and that is that the wrong test results could be given out to the wrong people, that the test results could be inaccurate. And remember that CLIA was enacted, and the entire laboratory inspection system nationally was enacted at a time when there were problems with, for example, the chain of custody of specimens, the accessioning process of specimens, the validity of testing, lack of quality control in laboratories. CLIA was enacted a number of years ago, and there was an inspection system which at first was within Centers for Disease Control, later moved to, when CLIA itself moved into CMS about 35 years ago. The idea was to create a national quality assurance system to make sure that people were getting their own lab results, and we're getting lab results that were from validated testing, and that the lab results were run by labs with people who were qualified, knew what they were doing, and that that we could depend, and providers could depend on the results. And of course, many laboratories that perform the research studies, as I said, are not CLIA certified, and therefore, under CLIA, they cannot report test results to patients for the diagnosis, prevention, or treatment of any disease or impairment of, or the assessment of the health of individual patients. This is what the actual regulation within CLIA says with the citation here. Here's the problem, though. Our research laboratories, let's say within the University of Connecticut Medical Center complex, a research laboratory that is not the regular CLIA-certified pathology laboratory, it is nevertheless part of a HIPAA-covered entity. So therefore, and here's the inconsistency, it cannot give out, under CLIA, these test results from a non-CLIA certified laboratory. On the other hand, it's part of a HIPAA-covered entity where the new rule demands that HIPAA-covered entities, including the non-CLIA certified laboratories, if they're part of a covered entity, give people access upon request to their test results. And therein lies the problem. So HIPAA requires us to honor individual right of access within our covered entities, and CLIA forbids it when our laboratories within a covered entity are not in fact CLIA certified. Now, before this final rule, as I said before, there had been this kind of exemption which took care of this, because it actually, the earlier incarnation of the HIPAA rule, as I said, indicated that laboratories, including research laboratories, were not required to hand over their results, even if they were part of a covered entity. So therein lies the regulatory conflict. So as I said, under HIPAA, just to repeat, make it crystal clear, under HIPAA, covered entity, laboratory, non-CLIA certified, must hand over upon individual requests the results, but under CLIA, if it's not a CLIA certified laboratory, regardless of HIPAA, it is actually a felony under federal law to hand over test results. You can lose, and ultimately, your entity, your entire corporate entity, could lose its CLIA certification for having a research laboratory that is non-CLIA certified handing over test results to individuals. And this is why in these in the burgeoning area of biomarker and genetic research done by the non-CLIA certified laboratories, this is why we're so concerned about this issue. So then we said to CLIA, a number of us, including the several presentations made at the HHS Secretary's Advisory Committee, we said, well, what about if instead of handing people over their results, instead of this from a non-CLIA certified laboratory within a covered entity, what if we tell them instead, there is a test result. This is when we think that a test result is actually actionable. In other words, let me give you the scenario. A genetic test, a genetic sequencing that done in a non-CLIA certified laboratory that indicates a genetic variant, that indicates in turn either a prognosis or a diagnosis, but something for which the individual could actually do something, could actually take care of their health by having more regular monitoring, by going to a physician who specializes in that disease or condition, et cetera, an actionable result. And remember, there are two sides to this. One side about the non-CLIA, about the non-CLIA certified research laboratory, one side of it is responding to an individual demand or request for their medical records, including their lab records. That's responding to the individual. That's one perspective. The other perspective is voluntary, spontaneous disclosure to an individual of test results that we find are actionable, even though those test results come from a non-CLIA certified laboratory. So if you find, for example, the BRCA gene in a research study, if you're a researcher, you have a non-CLIA certified laboratory, you identify a genetic variant that actually is actionable, and the individual does not know enough to ask for his or her records, are you allowed voluntarily to disclose that to the individual? Well, CLIA says if it's not a CLIA certified laboratory, you're not allowed to do that. So then we said to CMS, well, what about if instead of telling someone what their result is from the non-CLIA certified laboratory when we think the result is actionable, instead of telling them the result, we instead tell them or tell their physician, we have reason to believe that you should get a genetic test for BRCA. And so please go get it from a CLIA certified laboratory. Or you tell the physician, please order it from a CLIA certified laboratory so that that laboratory will actually be able to give the result. So we said to CMS, instead of giving the result, can we just use the result to refer a patient to a CLIA certified laboratory? The answer from CMS was no. That's a violation of law as well, because you are influencing treatment of the individual by handing over information that would lead them to make some decision about their health, and it's from a non-CLIA certified laboratory. So that too, they said, is illegal. So this is the regulatory regime that we are under. So then we said, well, what do you want us to do when we have a non-CLIA certified laboratory that shows a genetic result or a biomarker result that is actionable? And they said, well, the solution is simple. You should tell your research labs to get CLIA certified. That's what they said. So we said the transaction costs are high for that. Most of our research individual, if you think actually of the secondary, the unintended secondary and tertiary consequences of all research labs being required to be HIPAA certified, to be CLIA certified, you can imagine what that is. It would actually extinguish all of these individual laboratories within our academic institutions, and instead there would be a mass research laboratory, which may have the benefit of being CLIA certified and perhaps having a wonderful accessioning system, but it would certainly have a derivative effect of squelching all the innovation that happens and the learning and the education that happens in all of these individual research laboratories around the country. We also said, by the way, that doesn't get us out of all the problems, because some of these research test results actually don't have validated test equivalents within CLIA certified laboratories. So they may indicate something for which one could run another test, but the test itself would not even be available within a CLIA certified laboratory because not validated, or because the test itself is a research cutting edge test. So then, with all of this as the background, SACRP did step in, and we had several sessions in which we discussed in Washington, in one case with CMS, actually in two cases with CMS representatives present, and we made some recommendations. And it included the recommendation, which I think is pretty obvious, and that is that we believe, and I'm not a member of SACRP at this point because I'm maxed out on my term. I'm instead of the co-chair of one of the subcommittees of SACRP, the so-called Subcommittee on Harmonization of Research Regulations. And we recommended, SACRP itself and the subcommittee recommended to CMS that in fact it ought to be allowable, or there ought to be some enforcement discretion or enforcement waiver, so that it would be permissible to use a non-CLIA certified laboratory test result to refer the individual to a CLIA certified laboratory, or to refer the individual to a provider who in turn could order a test from a CLIA certified laboratory. This is what we said. We also said, which is I think important even if there is no regulatory change by CMS, that it's very important in biomarker or genetic testing research, genetic sequencing research, that the IRBs, the research administrators, the IRB staff, and most importantly, the investigators and the research team think very carefully before they enter into a study as to whether their non-CLIA certified laboratory will be producing results that actually will be actionable. They need to think about this before they end up, after the horse has already left the barn, and they see that they've got all of these incidental genetic variant findings that they never anticipated, and there's been nothing in the informed consent, nothing in the protocol, no consideration, nobody knows what to do with these incidental findings. It's much better to anticipate this and plan on it. I mean, if you plan to violate CLIA, at least plan to violate CLIA in advance. So, there's a judge here in Connecticut at the Second Circuit named Guido Calabresi, and some of you may have heard of Guido. He taught it. He still teaches at Yale. He was actually one of my mentors many years ago. And Guido would tell a story in his first year torts class, which is toward the law of civil liability, of medical malpractice, and injury law, et cetera. And basically, the story goes like this. It says that many years ago, a few hundred years ago, before there were cars, there was a very learned judge, and he was riding in a coach, and some firecrackers went off. He was in his coach, and there was a coachman who was driving the horses, and firecrackers went off. Scared the team of horses, so the horses took off through the town, running. They were not able to be controlled by the coachman. And so the learned judge, realizing that there was going to be an accident, leaned out to the coachman and said, "Whatever you do, hit the cheapest thing." In other words, he knew that he was going to have to pay for something. So hit the haystack instead of the person, please. So in regard to CLIA and HIPAA, when you are faced with the choice of either violating CLIA or violating HIPAA, and you believe that there is an actionable result, a health critical result that has been produced by a non-CLIA certified laboratory in the course of a research study, I mean, what's the cheapest thing to hit? Is it to conceal the result or not give over the result to the individual, and therefore obeying CLIA, or is it better to disobey CLIA and hand over the result that is subject critical? I mean, to me, and when I advise clients, including perhaps some of you in this room, I always say, I would rather be indicted by CLIA for handing over a health actionable result, or at least using it to refer a patient to a CLIA certified laboratory, which is the best thing that one could do. I would rather endure that prosecution by CLIA, by CMS, than to have an individual in whom my researcher had identified a truly health actionable result like a BRCA gene and remain silent. Now this is shocking to compliance officers, but when one has to make a choice, I would rather choose the safety of the patient and the research subject and their interest over the folks who are the CMS enforcement people. So, but it's important to try to anticipate this before you get into the soup, and think about it when you have a research study. When you have a research study that is going to do genetic sequencing, that is going to do biomarker testing, when it's going to be done in a non-CLIA certified laboratory, flag it beforehand and send it back to the investigator to think about what he or she is going to do with these results before you get them. There was guidance that was issued by HHS Office of Civil Rights about this HIPAA-CLIA change that happened in 2014, but the guidance did not tell us what to do about this. I think OCR would like to tell us what to do about this, but they are hostage to the enforcement folks within CMS as well. So, what should you do as a HIPAA-covered entity? And again, I'm not talking about the voluntary disclosure, I'm talking about an individual at this point when he or she demands a copy of their designated record set, which may include results from a non-CLIA certified laboratory within a HIPAA-covered entity. What do you do? Well, one thing you need to do is I would suggest that you talk to your HIPAA privacy folks within your covered entity and come up with a definition of designated record set. Because a DRS is often, which is what their individual has a right of access to the DRS. And so however a DRS is defined in your policies is going to be somewhat determinative as to how one responds to that demand. Review your research studies, as I said, that have genetic testing or biomarker components. Review your practices of your researchers in regard to whether they are returning results to patients. The last thing that you actually want is a researcher surreptitiously to be disclosing things to subjects without the IRB even knowing about it, because that would be a violation of the protocol. Protocol didn't have it, and that's an important step in the research, then doing it outside the protocol is not a good idea either. And educate your IRB staff and your research team members, including your investigators, to spot these issues. Now, finally, let me just say a couple of words about the FDA. The FDA regulations also impact the return of results, and in a way that is oblique, but it actually is quite important, especially in regard to genetic testing. Many biobank studies, as you know, involve the performance of experimental and unvalidated laboratory tests. And some biobanks, in order to encourage participation, actually would like to return results to subjects. And by the way, I can tell you that there's another current that not in the slides, but that I do want to mention to you, and that is that there are a number of pharma companies and biotech companies that have biobanks and that are doing genetic testing on their biobanks that are asking themselves the questions right now as to whether they should return actionable results. We're going to see developments on this. It's too soon. I can't disclose client confidences because I advise both pharma, biotech on the one hand, and also academic medical centers on the other. But I can tell you that this issue is in ferment in regard to the privately held, industry-held biobanks and the genetic sequencing that is going on in them in their secondary research. Some laboratory tests may be categorized as an in vitro diagnostic subject to FDA jurisdiction. And in fact, the FDA has taken the position that an algorithm, a computerized algorithm, which applies to it, which takes genetic sequences and interprets them, that itself is an IVD, is an in vitro diagnostic, because it is taking data and using a mechanical means to interpret the data and give a result that would be fed back to the individual and his or her provider that would influence health. That is regarded by the FDA potentially as an in vitro diagnostic. And when it's an in vitro diagnostic, you've got to get an IDE from the FDA to use it. Then you have to go through first, of course, if you decide that it's an IVD, you have to, as an IRB, go through the issue of whether it is a significant risk device or whether it is not. If it is significant, and remember that significant risk for these purposes includes the risk of misdiagnosis or error in treatment caused by inaccurate test result if the harm is life-threatening or could result in permanent injury. So one has to, as an IRB and as an investigator, one has to decide if it's an algorithm, if it's an electronic algorithm that is interpreting genetic test results or biomarkers, then is it significant risk or non-significant risk? If it's significant risk, you actually have to get an IDE from the FDA before you can go forward with the research. If it's a non-significant risk device, then you have to meet a number of requirements. You've got to get, the investigator does not have to go to the FDA, but he or she has got to get IRB approval. They've got to get proper labeling. They've got to monitor. They've got to do informed consent, and they've got to have proper record keeping in order to keep themselves exempt from the investigational device exemption requirement. This IDE, this extent of jurisdiction, this interpretation of jurisdiction by FDA is not immediately understandable. And there are some investigators and some companies, for that matter, who have proceeded, in my experience, with these kinds of use of algorithms without even considering the FDA potential here, but do consider the FDA potential. So finally, in conclusion, if the results are going to be returned, then I would suggest, or if you think that even if you don't plan to, your research is going to generate results that the investigator will want to return or may want to return, think about the following questions. In what type of facility are the results generated? CLIA certified, non-CLIA certified, covered entity under HIPAA, non-covered entity under HIPAA? Can the test result actually be performed in a CLIA certified laboratory so that at least you could use the result from a non-CLIA certified laboratory to refer the individual or subject or his or her physician to a CLIA certified laboratory? If there is no analogous test that's possible in a CLIA certified laboratory, then you're back in the pickle because you can't even use the result from a non-CLIA certified laboratory to refer the individual. You either have a choice. You can give them the information or not if the information is actionable. Would the results be used to care for the patient or influence the treatment decisions? Have the test results been validated by another established procedure? Who will return the results? Should it be the investigator or should it be a genetic counselor, for example? And what information will accompany the results that will be returned? And with that, I will stop and thank you for your attention.